Good afternoon. We begin with the third session, which is devoted to a role of insurance companies under the new scheme. And for this particular session, we have with us this afternoon Mr. S.P Jain, advocate. Advocate since the year 1984, which makes a journey of 38 years as a lawyer. He's a blend of many things, not only a lawyer. True, a panel lawyer of the nationalized and the private insurance companies. He is the trained mediator. He is a keynote speaker. He is also a motivational speaker. Coupled with that, he's an author of 10 books. I sometimes wonder, how do you get time being a lawyer and yet you can produce books almost in a dozen for that matter? I admire your energy and passion, both as a lawyer and also as an author. Above all, for this particular session, Mr. Jain is the most befitting person to deal with the aspect of role of insurance companies. His contribution has been acknowledged by Justice Midda as also by Mr. Vikas Pava in the earlier two sessions. And therefore, we are keenly looking forward to Mr. Jain's presentation in regard to the role of insurance companies under the new scheme. Over to Mr. Jain.
Thanks a lot, sir, for inviting me and giving me this opportunity to address regarding the role of insurance company as per the new scheme. As per the new amendment brought forth in the Motor Vehicles Act, the role of the insurance company is basically to pay the legitimate amount of compensation to the victims of accidents who are really the sufferer. And in accidents, as Justice Midda has elaborated, thousands and lakhs of persons, either they suffered injuries or their breadwinner lost their life. Now, as far as the topic is concerned, we have to look forward to aspects which contribute major and important role as far as the insurance industry is concerned. As I said earlier, that the legitimate amount of compensation has to be given expeditiously. That is the objective of the entire statute. But the compulsion for the delay in such type of cases is being that many intermediaries are involved in getting this amount of compensation from the insurance companies. And in the garb of getting this amount of compensation, there is rampant increase of implicating the vehicles in hit and run cases, as a result of which even the Honorable Supreme Court in the case of Mohammad Safiq had given certain directions when such a number of cases was brought to the knowledge of the Honorable Supreme Court, wherein lakhs and crores of rupees of the insurance companies were diverted due to manipulation by the police officials, the advocates, their colleagues, the eyewitnesses, the driver and owners of the vehicles. These instances are not few instances, but they are increasing rapidly. I have come across the cases wherein the person has brought a vehicle just for the purpose of implicating the same in the hit and run cases. And in 1 year, he has implicated this said vehicle in 6 hit and run cases, as a result of which in 2 cases, he was able to grab lakhs of rupees, and thereafter, due to one reason or the other, it was brought to the knowledge of the insurance company that there is nexus between the advocates, police officials, the claimants, the driver owner, and by way of implicating these vehicles, they are defeating the entire object of the legislation. The same vehicle was involved in 6 cases in a year. The driver was same. All the cases were pertaining to hit and run cases. The owner was the same. The counsel was the same. And this is not the only example. Even the Honorable Supreme Court reached to the conclusion that this has to be stopped by any means. When we are going to contest the cases by taking our legitimate defenses, then the question arises how we are going to scrutinize whether this case relates to the genuine death or injury case, or whether this case is a false case, in order to exaggerate the amount of compensation from the insurance company. My humble submission for this is that whenever the judicial officers, they came to know that the case filed by the petitioners relates to a hit and run case and the vehicle has been implicated, or that the fake claim case is in order to get the exaggerated amount of compensation, then not only dismissing the case is enough, but the penal law has to be taken care of, and the persons who are really involved in all these activities, they have to be punished as per law. Then only we will be able to say that the system is not corrupt. It is going to fulfill the objective of the legislation. Now, as per the new scheme of the Motor Vehicles Act, when I was going through the entire subject or the amendment of the legislation, then I came to know that there will be speedy justice to the victims of accidents as per the scheme formulated and the rules made thereunder. In my personal opinion, if we are going to go for the letter and spirit of the legislation, then there is no reason that every case cannot be decided within a period of 1 year. 1 year period is not a small period. And if we are going to the words by word of the legislation, then we can easily understood it and we can get it implemented so that the victims of accidents, they may get their legitimate amount of compensation within a period of 1 year. The process introduced by the legislation is so simple that the learned tribunals, if they are eager enough to decide all these cases in a bound down period, then there is no reason that the same cannot be decided. In my practice, I had gone through such type of number of cases wherein despite all these formulations, because in Delhi, it is going on from a long time. that the detailed accident reports are furnished by the police officials before the learned tribunals, and out of 21,000 cases, 11,000 was decided on the basis of detailed accident report. But at the same time, I prepared the list also on this aspect and found that there are cases which are pending for final arguments for years. There are cases which are pending for final orders or the judgment for more than a 6 month, 9 months, or 1 year. This system, if it is going to work as per the enactment of the Motor Vehicles Act, the Central Motor Vehicle rules, which are going to be effected from 1st of April 2022, then each and every aspect of the case can be very well looked after within a period of 1 year, and the case could have been decided without any difficulty. Now, as far as the amendment in the Motor Vehicles Act is concerned, I would like to highlight certain aspects of the amendments which are very necessary to be adjudicated by the higher authorities, so that the insurance company may not feel any difficulty in depositing the amount of compensation. But at least the law must be clear on this aspect. My first contentions before this session is this, that there is limitation period introduced by the legislation by way of amendment, and as per section 166 subsection 3, now the application seeking compensation has to be filed within a period of 6 months, and in case if the application seeking compensation is not filed within the period of 6 months, then it will be time barred. Now, as per subsection 4 of section 166, whenever any report relating to the accident is to be filed by the police officials, then it has to be treated as a petition seeking compensation by the claimants. Now the question arises, suppose the claimants did not file the petition within a period of 6 months, and the police officials, they file the detailed accident report instead of 90 days. Suppose they are going to file it after 6 months. Now, whether the court can discard the said detailed accident report on the basis that it is time barred. In case the said detailed accident report is accepted even after 6 months, then the provision introduced by the legislation will become redundant. There will be no use of that provision, because as per the amendment, in every accident case which has been lodged by the police officials, then they have to submit the detailed accident report before the learned tribunal. And due to one reason or the another, if they are not going to file the detailed accident report within a period of 1 year, then in case the court is going to accept it, then the provision is going to be redundant. And in case the report is not to be accepted, then there will be huge loss to the claimants. Now, this interpretation has to be given by the higher or highest court, so that the insurance company may also come to know whether the case instituted after 6 months, either by the claimants or by the police officials in the shape of detailed accident report, is to be legitimate or not. It has to be entertained by the learned tribunal, or it has to be dismissed by the learned tribunal as time barred. Previously also, there was no limitation period, and as per Article 113 of the Limitation Act, whenever there is no limitation provided for the filing of the suit, then it has to be treated as 3 years from the date of accrual of the cause of action. However, in the case of C. Padma, the Honorable Supreme Court has given a different interpretation when the said period of limitation was removed from the statute. As per the dictum of the Honorable Supreme Court, when the period of limitation was removed or deleted from the statute, then they were of the opinion that it means there is no limitation period, and the suit or the petition or the application seeking compensation can be filed at any point of time. As a result of which, there are petitions or applications which had been filed even after 28 years of the accrual of the cause of action. The Honorable Supreme Court, in the case of Rohit versus Khatun B, decided on 9th of February 2017, had been pleased to dismiss the said application seeking compensation on the ground of barred by limitation. Although previously the judgments were there of the apex court that the application for compensation can be filed at any point of time. So when we are going to render the judgments or the orders in respect of the period of limitation, then this contentious issue will arise whether the detailed accident report, if it is filed after 6 months, whether can be entertained by the learned tribunal, or it has to be dismissed on the basis of Section 166, subsection 6, subsection 3 of the amended Motor Vehicles Act, which prescribe the period of 6 months as the last minute for the maintainability of the claim application for the victims of the accidents. So there is no clear-cut specification or the explanation what would happen if the detailed accident report is filed after the period of limitation that is fixed for 6 months. The insurance company at that time has to go either by the Section 166, subsection 3, or it has to be decided by the higher or the highest court, so that the issue can be cleared whether the limitation is applicable to detailed accident report or not. The second contentious issue is regarding the removal of the or deletion of the Chapter 10 of the Motor Vehicles Act. Chapter 10 of the Motor Vehicles Act was dealing with the issue of interim compensation to the victims of accidents. Now, as far as this chapter is concerned, it is deleted from the statute by amendment, And as per section 164A of the amended Motor Vehicles Act, the scheme for interim relief for claimants has to be formulated by the government, and the central government has to decide what will be the quantum of compensation as interim relief to the victims of accidents. Who is going to pay this interim compensation? The previous Motor Vehicle Act, it was mentioned in the Act itself that in case of death, 50,000 is to be awarded as interim compensation. And in case of permanent disablement, the interim compensation would be rupees 25,000. But since Chapter 10 has been deleted from the statute, and now the power in respect of the interim relief to the victims of accident has been taken over by the central government, and till date, although the Central Motor Vehicle Rules and the Motor Vehicles Act has come into operation with effect from 1st of April of this year, but still, in respect of this interim relief, no such rules are framed by the central government, and it is difficult to assume that if the accident had taken place after 1st of April 2022 and any petition or detailed accident report is filed before the learned tribunal, then whether the claimants, they will be able to get the interim relief from the learned tribunals or not, because no such clear-cut legislation, rules or enactment is there. What would be the amount of interim relief? Who is going to pay this amount of compensation? This is in abeyance till date. No rules are formulated by the legislation. The legislation has to formulate the rules. Thereafter, the position will be cleared. What will be the amount and who is going to pay this amount of compensation? Now, the third contentious issue for the insurance company to make the payment of compensation relates to the liability of the payment of compensation in case of the WC liability as per section 147, which was relating to the prior to the amendment of the statute. The WC liability was also inbuilt under the Motor Vehicles Act, and thousands of cases emerging from the vehicles involved in such type of cases were used to be filed before the learned EC commissioners. The learned EC commissioners, on the basis of the issuance of the policy in relation to the vehicles wherein the driver, conductor, laborer, or the examination of ticket checkers, they used to take the cases and decide the cases as per Employees Compensation Act. The said provision in respect of the coverage of the liability of the Employees Compensation Act was inbuilt as per section 147. Now, that provision has been deleted from the statute. And now the question is whether the driver, the cleaner, the laborer, they will be entitled to get the amount of compensation under the WC Act or not. To my mind, the situation is clear that since in the definition of third party, section 145, subsection 1, the third party definition includes driver and other co-workers on a transport vehicle. Therefore, now the drivers or the co-owners in a commercial or transport vehicles, instead of invoking the jurisdiction of the Employees Compensation Act, they have to invoke the jurisdiction of the learned tribunal constituted for the purpose of MACT only. Because in case the negligence of the driver is there, then he can claim the amount of compensation under section 164 of the Motor Vehicles Act. However, in case the co-worker of the transport vehicle is involved in the accident and he is of the opinion that the accident was caused by the driver of the vehicle, then he can invoke the jurisdiction of the Motor Accident Claims Tribunal and either can file his claim for seeking compensation under section 166 or 164 of the Motor Vehicles Act. However, as per my opinion, the jurisdiction of the learned EC Commissioner as per the new act will be barred because of the deletion of the proviso from section 147 of the Motor Vehicles Act. This has to be effected as far as the liability of the insurance company is concerned. Previously, most of the cases which are pending before the learned EC commissioners, they were related to the vehicles, and insurance company in those cases were a necessary party and they used to pay lakhs and crores of rupees in case the vehicle is involved and the driver, conductor or the helper, either they sustained injuries or they have died due to the injuries sustained in the accident. This issue has to be also decided by taking care of section 147 and the other relevant provisions of section 145 coupled with the relevant enactment of Employees Compensation Act. This is going to affect the liability of the insurance company to some great extent. Now, the other aspect of the liability of the insurance company is concerned. The defenses were enumerated in the previous legislation under section 149 subsection 2 of the Motor Vehicles Act. There is amendment in the said section 149 also, and more grounds are also inserted which were not there in the previous legislation. Now the insurance company, as per the new enactment, they can take the defense of non-payment of premium and that the vehicle was driven by the driver under the influence of liquor or drug. These two defenses were not available in the previous statute. However, the other defenses relating to the driving license, permit, etc. are remain the same. The particular aspect on which we have to concentrate is, as per the previous legislation, the insurance company, in case they are going to establish the breach of the terms and conditions of the policy by leading evidence on their behalf, they used to get the rights of recovery against the insured persons. First of all, as per section 149, subsection 4 of the previous statute, the insurance company were liable to deposit the entire amount of compensation in favor of the claimants, and after deposit of the compensation amount, they were entitled, as per the judgment, to get it recovered from the insured. They need not to file a separate suit or petition for seeking the recovery rights. Rather, after depositing the amount of compensation before the learned tribunals in favor of the claimants, the execution was filed against the insured, and the learned tribunals, they used to take the coercive methods for the recovery of the amount deposited by the insurance company. In the new statute, subsection 4 of section 149 has been deleted. That was the section which provided for the rights of recovery in favor of the insurance company. Now, as per the new statute, section 150, the insurance company can defend the application seeking compensation by taking the defenses of driving license, the permit of the vehicle, no premium has been paid, or the check has been dishonored which was given by the insured towards the premium for the policy, or the vehicle was driven under the influence of liquor or drug. They can still defend the cases by taking all these defenses. But the question arises, when they are able to prove the breach of the terms and conditions of the policy by the insured, then when the proviso is not there now, subsection 4 is not there now, then what will happen? Whether they will get the rights of recovery only, for which there is no such provision, or the insurance company has to get this amount out of the fund which is to be created by the central government under section 164B of the new legislation. These are the areas which are still gray areas for which no explanation is there. In case the insurance company is able to defend the application seeking compensation, and they are able to establish that there was violation of the terms and conditions of the policy, then what would happen to their rights? In case the breach of the terms and conditions of the policy, then there must be some remedy in favor of the insurance company, either from the motor vehicle accident fund, which is to be created by the central government under section 164B, or against the insured, or by any process of law, for which also the law has to be decided by the higher or the highest court. Till then, it will be difficult for the insurance company to deal with the cases wherein the question of the violation of the terms and conditions will arise. The next contentious issue regarding the liability of the insurance company is based on section 147 subsection 2, which says that the base premium and the liability of the insurance company has to be established by the central government by making rules. It may be that the central government may fix the minimum premium and the maximum liability of the insurance company as per section 164C bracket 1 and bracket small k. The liability of the insurance company in case has to be determined on the basis of the premium received. Then, since the legislation is already notified, but there is no such guidelines or there are no such rules which have been enacted till date regarding the minimum premium or the base premium or the maximum liability. Till then, this will be a difficult affair for the insurance company to deal the cases which has been committed after the 1st April 2022. The central government has to enact the rules immediately so that the position regarding the minimum premium and the maximum liability of the insurance company may be on record. Till then, all the things will remain in abeyance and it will be difficult to calculate which is the amount to be paid by the insurance company to the victims of the accident. Next aspect of the enactment is whether the enactment is to be applied retrospectively or prospectively. There is no mention in the new statute or the amendment whether it will be applicable to the cases which are already pending before the learned tribunals or it would be prospective in nature. As far as there are so many deletion and insertion in the statute is there which are going to affect the claims of third parties. Therefore, the question is, in case the legislation has to be prospectively to be applied, then many questions will arise. Whether the liability of the insurance company, the period of limitation for which the application is to be filed, and similarly, whether the defenses available to the insurance company can be taken in the cases which have already been going on. That aspect also require consideration by the higher or the highest court. The Honorable Supreme Court, in many cases, has already decided that as far as the procedural law is concerned, it is always retrospective in nature if it is not specifically written. And in case of substantive legislation, it is always prospective in nature. As far as the Motor Vehicles Act is concerned, it is both it is procedural law as well as substantive law. It decides the rights and liabilities of the parties also, and at the same time, it decides the procedure also. And when we are going to discuss about this aspect regarding the application of the enactment, whether it is going to be applied retrospectively or prospectively, then we have to consider at least two judgments of the Honorable Apex Court, wherein the Honorable Supreme Court has made a clear distinction between the amendments which are usually and generally in relation to general amendments and the amendments which are related to the social welfare legislation. The Honorable Supreme Court in the case of Union of India versus Radha Yadav, which was decided in the year 2019, and in the case of Union of India versus Dilip, decided in the year 2020, has taken a different view in respect of the applicability of the amendments in social welfare legislation. Therefore, when the major amendments are there in the Motor Vehicles Act, which is going to affect every aspect of the adjudication, every aspect of the settlement, every aspect of the liability of the insurance company, the limitation period, etc., etc., then it has to be decided whether this enactment would be applicable to the cases which are pending before the learned tribunals, or it would be applicable only for those cases wherein the accident had taken place after 1st April 2022. This is required at the earliest because within a short period, the applications seeking compensation under the new enactment will start coming to the learned tribunals, and they have to proceed further in those cases also. And in case the dilemma is not eliminated or it is not resolved, then there will be different judgments by the different learned tribunals, which will create so many problems and difficulty, and many appeals and SLPs will be filed in order to know whether the amendment is prospective in nature or it is retrospective in nature. All these things, they are going to affect the liability of the insurance company. The next contentious issue I would like to discuss in this session is that there are certain difficulties in the assessment of compensation, and the question relating to the liability of the compensation to be borne by the insurance company is firstly related to the death of the minor persons. The cases wherein the minor had expired and there was no dependency on the minor and there was no income of the deceased being minor, the question in many cases arises whether the judgment given as far as Delhi is concerned there was a judgment in the name of Chetan Malhotra versus Lala Ram, decided by the Honorable Delhi High Court on 13th of May 2016, wherein the Honorable Delhi High Court, in the case of the death of the minors, had given a new subjective approach for the calculation of the amount of compensation. As per this judgment, the second schedule was taken into consideration and the cost of inflation in index was considered because the second schedule came into force on 14th of November 2014, and thereafter there was no increase in the notional income by the central government, which was required by the central government as per the enactment. The Honorable Delhi High Court had taken care of these inflations, and at the time of assessment of compensation for the death of the child, they had used the CII method to take into consideration the inflation since the year 1994, and 1994 was considered as the base year. And on the basis of CII and the multiplier system, whatever the compensation amount was assessed, the same figure was again added towards non-pecuniary amount of compensation. This assessment of compensation was based upon the second schedule of the Motor Vehicles Act. Now, as far as the new amendment is concerned, this second schedule has also been deleted. It is no more in the legislation. When the second schedule is not in the new legislation, it means the judgment passed by the Delhi High Court in the case of Chetan Malhotra will also not survive, in my opinion. And some new law has to be developed in view of the amendment in the Motor Vehicles Act. Previously, prior to this Chetan Malhotra judgment, there was one very authoritative pronouncement by the Honorable Supreme Court in the case of R.K. Malik versus Kiran Pal, which was decided on 15th of May 2009. In that case, the Honorable Supreme Court had given the guidance how to assess the amount of compensation in case of the death of the child. Now, that judgment is also not relevant because that was also based upon the second schedule of the Motor Vehicles Act. Now, once the second schedule is not there and the death of the minors are still there, the petitions are going to be merged on the judicial records of the learned tribunals. And in many of the cases, the insurance company used to decide the cases previously on the basis of R.K. Malik judgment, and thereafter, as far as Delhi was concerned, on the basis of Chetan Malhotra judgment. But once the new amendment is there, which is going to affect both these judgments, because both the judgments were based upon the second schedule, which is no more there, which has already been deleted. Now some new law has to be developed. And what would be the new law? What would be the liability of the insurance company in relation to the death of the child? Till then, it will be difficult for the insurance companies to offer the amount of compensation in case of the death of the minors. The next contentious issue which is in relation to the liability of the insurance company, is relating to the non-pecuniary amount of compensation, which is also substantial and is very important as far as the settlement and the adjudication of the cases are concerned. The Honorable Supreme Court, in the case of Parnassetti judgment, which was delivered on 31st of October 2017, had decided, it is a constitution bench judgment of the Honorable Supreme Court, which is applicable throughout India to all the tribunals and the high courts. In that judgment, it was specifically and categorically decided that in case of death, the claimants are entitled to get a sum of rupees 70,000 towards non-pecuniary amount of compensation, and that compensation has to be increased by 10% after every 3 years. Now, once the Constitution bench had given their authoritative pronouncement on the non-pecuniary amount of compensation, then there are many other judgments by the Honorable Supreme Court itself, wherein the Constitution bench judgment was deviated. Firstly, it was deviated in the case of Magma General Insurance Company versus Nanu, which was decided on 18th of September 2018 by the Honorable Supreme Court, and it was a DB judgment, division bench judgment, wherein instead of the compensation of rupees 40,000, which was granted by the Constitution bench judgment, the Honorable Supreme Court had given the judgment that the claimants are entitled not only for spousal consortium, but for parental consortium also. As a result, for each and every claimant, the amount of compensation was awarded towards non-pecuniary consortium amount of compensation. The question had been raised by the insurance company and by the claimants also, wherein they did not get the amount of compensation as per the judgment of Magma versus Nanu. The issue was whether the constitutional judgment is going to prevail or the DB judgment, which was Magma versus Nanu, is going to prevail. Because the judgment of Magma versus Nanu was completely in deviation of the Constitution bench judgment. Therefore, the issue is still pending. And thereafter even, there are many judgments in the name of United India versus Satinder, New India versus Somvati. And in all these cases, the Honorable Supreme Court has not adhered the constitutional bench judgment, and different amount of compensation towards non-pecuniary has been awarded, as a result of which there is a difference of opinion. And in many high courts, the high courts are going to adhere to the judgment of Magma instead of Parnassetti judgment. As a result, the settlement cases are not in tune. Either the claimants, they are going to refuse, or the insurance company, they are not going to adhere to the Magma judgment. Now, as far as the new legislation is concerned, since the second schedule is not there, and since there is different judgments of the Honorable Supreme Court on the same subject, Therefore, this is also going to create some problems for the settlement and the adjudication of claim cases even as per the new enactment. The next contentious issue which I would like to discuss is that in order to effectively handle the fake claim cases, there is a good enactment by the Central Motor Vehicle Rules. And as per Rule 25, an application can be moved by the insurance company whenever they are of the opinion that there is a fake claim and the vehicle has been implanted in the hit and run cases or fake claim case has been filed in the court. The insurance company can move the application to the DCP by requesting them to call for the record of the service provider in respect of the mobile number of the driver. In case there are cases wherein by tracing the location from the service provider, it has emerged on the record that the driver, which was shown as the driver of the offending vehicle, was not there even on the spot of the accident, and he has been implanted in the case just to facilitate the amount of compensation by the insurance company. His location was somewhere else, but it was shown, and even in some cases, the admission of the driver is there that his vehicle was involved in the accident, but actually his vehicle was not involved in the accident. He was inserted or implanted in the criminal case so that the amount of compensation can be given to the claimants by the insurance company, and later on, the said drivers, they are acquitted by the courts by not having proper evidence against them. This was going on in collusion with the claimants and other persons. Now, the last my contentious issue is that to facilitate the expeditious disposal of accident cases by the learned tribunals, there is Rule 30 in the Central Motor Vehicle Rules, which are enacted and is to be effective from 1st April 2022. That evidence before the learned tribunal now can be by the appointment of the local commissioner. The local commissioner can be appointed by the learned tribunals, who can sit in the courtroom itself and record the evidence of the claimants or the insurance company. And the insurance company has to pay the amount of the professional charges to the local commissioner. In my opinion, by inserting this rule, lot of work of the tribunal will be saved, and they will be able to concentrate on the passing of judgments or orders. And by giving this opportunity to the young advocates, the lot of time will be saved and the claimants will get their legitimate amount of compensation within a short period. This aspect of local commissioner, appointment of local commissioner for the purpose of evidence, is very well going on in Haryana. I had gone there in one case, and I was really appreciate this valuable contribution by the Haryana judicial authorities, that they used to take the evidence by local commissioners. As a result, lot of time of the court is saved, and they are able to concentrate on passing and adjudicating the accident cases within a period of 1 year. This is in relation to the amendment, and lot of requirements are there But one thing is certain, that if we are able to implement it in letter and spirit as per the objective of the legislation, then the injured or the persons who have lost their life, their family members, they would be able to get the amount of compensation within a period of maximum 1 year. And this will be solace not only to the family members or the injured, but to the entire system also. If we are able to get the scheme implemented, then not only the claimants, they are going to be benefited, but the insurance company, they will be able to save lakhs and crores of rupees towards payment of interest, because nowadays the matters relating to accidents are kept pending for 5 years, 10 years, or some long periods. Therefore, it is for the entire judicial setup, for the claimants, for the insurance companies, for the driver and owners, it is beneficial for all these things. And therefore, the insurance company has to bond their liability wherever it is possible, and they have to give the amount of compensation, which is the legitimate right of the claimants. Thank you very much, sir. Over to Dr. Balram K. Gupta ji.
Thank you so much, Mr. Jain. I know it's not a biopsy, but a full surgery about the role of the insurance companies in this particular domain. Grateful to you for sparing the time and being with us. And we look forward to have you again in some other program as well. Kind of you. Thank you so much.
Thanks a lot, sir.